Article 15. Freedom from torture or cruel, inhuman or degrading treatment or punishment. This article begins with 3 comments highlighted in panels. Understand that seclusion and restraint is cruel and inhumane treatment and there is no justification. Loopholes should be closed. Hui participant. Abusive practice, pinning people down, removing clothing to inject drugs. Hui participant. Broadened definition of seclusion and restraint beyond physical includes social, emotional deprivation. Hui participant. Introduction. Article 15 states that no person, with or without disability, should be tortured, humiliated, or treated cruelly. Disabled people also have the right to refuse to be part of medical or scientific research. These rights should be protected by effective administrative, legislative, and judicial measures. General comment. This article is important due to the existence of some legislation in New Zealand, previously covered in Articles 12 and 14, that allows compulsory assessment and treatment. Disabled people who are subject to such assessment or treatment must not be subjected to any form of torture or cruel, inhuman or degrading treatment or punishment. Article 15 is also relevant to disabled prisoners who, on many occasions, require reasonable accommodation so that they can access all services in the prison environment. Importance of Article 15 to disabled people in New Zealand. Realisation of the rights in this article is needed to protect disabled people who have been deprived of their liberty. Disabled people living in prisons or other secure facilities are amongst New Zealand's most vulnerable people and do not have regular access to the same services and facilities the general public does. Current place of Article 15 in law and practice. At present, no legal measures have been taken to eliminate the use of seclusion, restraints, night safety orders, tie-down beds, and non-consensual treatment. However, the government has advised it is committed to reducing the use of seclusion, restraints, and other similar measures. In April 2019, the Department of Corrections removed tie-down beds from Intervention and Support Units, ISU, in prisons. Endnote 130. Further, the government has published guidelines on night safety procedures and aims to eliminate this practice by 2022. Endnote 131. A process is also underway to restrict the use of mechanical restraints in prisons through the Corrections Amendment Bill. Endnote 132. The New Zealand Health Quality and Safety Commission has set up a zero seclusion policy, working in collaboration with 19 district health boards and Te Pō o Te Whakaaro Nui, a national centre of evidence-based workforce development for the mental health, addiction and disability sectors in New Zealand. The Commission's aim was to eliminate seclusion by 2020 through working with teams of consumers, their families and whānau, and service providers. As noted earlier, this time frame is now seen as aspirational. The elimination of seclusion has been part of New Zealand government policy for more than a decade, and reducing restrictive practices in mental health has been discussed for more than 20 years. New Zealand ratified the United Nations Convention Against Torture and Other Cruel, Inhuman or Degrading Treatment or Punishment, the Convention Against Torture, in 1989. Despite evidence that more than 90% of prisoners have a lifetime diagnosis of mental health or substance abuse disorders, Endnote 133, and a considerable number of prisoners have other disabilities, the Chief Ombudsman, in the role as a national preventative mechanism under the Crimes of Torture Act 1989, continues to observe disabled prisoners living in unsuitable prison environments. In recent inspections, a number of prisoners with physical disabilities who were assisted by either a wheelchair or a prosthetic had trouble accessing key services in a particular prison. Endnote 134. For example, deaf prisoners were observed as having not been provided with access to New Zealand Sign Language interpreting services or information on emergency procedures, given they would not be able to hear alarms. End note 135. This indicates that reasonable accommodation is not always being proactively considered. However, the Chief Ombudsman did observe an example of good practice of reasonable accommodation at the Auckland South Corrections Facility, which has installed in-cell telephones and user interfaces. This is a positive initiative that ensures disabled prisoners can effectively communicate. End note 136. The Chief Ombudsman has raised concerns that prisoners or clients in ISUs can be seen on camera by staff when they're naked or using the toilet. End note 137. The Chief Ombudsman considered this to be degrading treatment or punishment. The Chief Ombudsman has also publicly remarked on the circumstances of those living in secure mental health and secure intellectual disability facilities. For instance, in 2016, he stated it was cruel and inhuman that an individual was living in a sparse room with a mattress on the floor directly beside a de-escalation unit at a facility in Wellington. End note 138. This individual's mood was regularly affected by behaviour and noise of other clients, and they spent the vast majority of his time without mental or physical stimulation. In 2018, they were moved from the secure unit where they had lived for more than 8 years to more humane accommodation in the community, with appropriate support staff and services in place. End note 139. The Chief Ombudsman remains concerned about several other individuals who have been in secure intellectual disability services for extended periods and is currently undertaking a systemic investigation into facilities and services that encompasses a number of case studies. End note 140. The Chief Ombudsman also has long held concerns that overcrowding in secure mental health facilities can amount to degrading treatment under the Convention Against Torture, as can use of rooms such as day rooms, offices or seclusion rooms as long-term or temporary bedrooms for service users. End note 141. Concerns have also been raised regarding staff retention and high turnover rates, leading to security staff being used to assist with personal restraint in some facilities. End note 142. Committee's previous dialogue with the state on Article 15. In its 2014 concluding observations, the Disability Committee commented that New Zealand continues to use seclusion and restraint in some secure health and disability facilities. It noted that although there has been a decline in this practice, the situation at that time was not satisfactory. The Disability Committee recommended that immediate steps be taken to eliminate the use of seclusion and restraint in these facilities in New Zealand. Comment on the realisation of Article 15 in New Zealand. There is still work to be done to ensure that Article 15 is upheld in New Zealand. While there appears to have been a reduction in the use of some restrictive practices, including an end to the use of tie-down beds in prisons and seclusion in schools, the government has not moved to eliminate seclusion and restraint. In 2017, Dr. Sharon Shalev, an internationally renowned criminologist and expert on prisons, completed an independent review of seclusion and restraint practices in New Zealand. The review was funded by the United Nations Office of the High Commissioner for Human Rights. Dr. Shalev's report, Thinking Outside the Box, a review of seclusion and restraint practices in New Zealand, highlighted a number of serious issues. End note 143. These included high rates of seclusion and restraint, impoverished physical environments for people belonging to vulnerable groups, and concerns around the record-keeping associated with seclusion and restraint in various settings. End note 144. Māori and Pacific peoples experience seclusion at double the rate of other New Zealanders. End note 145. In 2017, a report undertaken by Te Pō o Te Whakaaro Nui found that while seclusion has reduced in recent years, there were differences in the use of seclusion by district health boards throughout New Zealand. End note 146. This is echoed by data from the Health Quality and Safety Commission, which shows that while seclusion rates have been declining since 2009, they have recently plateaued. End note 147. It appears that there is increasing knowledge in various settings that disabled people can request accommodation that meets their needs, particularly when they're in places of detention. The IMM is hopeful that organisations and individuals working in these environments will begin to proactively consider the rights of disabled people rather than simply respond to requests for assistance as required. Advancements have also been made in the education sector. The Education Update Amendment Act 2017 prohibited seclusion and regulated the use of restraint in New Zealand schools. As a result, no school should be secluding or isolating students. Restrictions on the use of restraint were also set, so this practice can only be used when serious and imminent harm is evident. Seclusion and restraint practices were a recurring area of concern at the consultation hui. Participants also strongly asserted that compulsorily medicating a person is both cruel and inhumane and should not be used in any setting. Many participants also felt that seclusion and restraint could be avoided with appropriate education and training for staff in prisons and secure healthcare facilities. It was also evident that people see seclusion and restraint in a much wider context than that defined in law or in treaties. Survey respondents and hui participants talked about the restraints imposed on personal freedoms and choices by services. For example, the removal of a disabled person's access to assistive equipment or sleep routines that suit staff rather than the disabled person. Recommendation. The IMM recommends that the government, 42, strengthens its commitment to reduction of rates of restraint of persons with disabilities and the rapid reduction towards elimination of use of seclusion in secure health and disability facilities through robust, achievable and time-bound policies. 43. Pending elimination of these practices, require district health boards to regularly release annual statistics indicating performance against these policies, including reporting comprehensive data relating to long-term stays in seclusion.